Case number 251740-M. Parent counsel.
Thank God on behalf of the people.
We are set for a pre-trial conference. It appears we have a resolution in this matter, Mr. Carnes.
Yes, Your Honor. My understanding is trying to the no contest as charged and people are supporting a delay of sentence. Cool special is successful on the delay. Success on the delay would be a written program is recommended recognition of the violation of probation.
Is that a kilogram?
Yes.
Okay.
The reason for the no contest plea is potential civil lack of.
And so just so we're clear, the success is completion of programming and no violation. That's all? Ms. Jones, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but it.
Yes.
Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. That is a 93-day misdemeanor and/or a fine of $500, and consecutive sentencing may be imposed if the offense happened in the place of confinement. Now, along with that, there's what's called a killabrew agreement. And what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence. And if you're successful with that delay of sentence, the case will be dismissed. Success means that you complete all the programming that your probation officer requests that you do, and you not have any violations. Do you understand that?
Yes.
Now, if I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that? Initially, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's incurred. A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that? Additionally, a no contest plea cannot be used against you. So if you were going to plead guilty and this person sued you, that guilty plea can be used against you. A no contest plea means that it's not. Essentially, you're accepting responsibility without saying that you did it. Do you understand that? And is that how you wish to proceed?
Yes.
Back on March 31st of this year, were you on probation or parole?
No.
Were you on bond in any other file?
No.
Then, Ms. Jones, to the offense that on or about March 31st, 2025, here in the city of Cadillac in Wexford County, how do you plead to committing the offense of assault and/or assault and battery?
No contest.
Counsel, I've been provided with a Cadillac Police Department report, incident number 2500819. It's been marked as People's Exhibit number 1. Mr. Carnes, do you move for its submission?
Yes, Your Honor.
Mr. Hartel?
Yes, Your Honor.
No objection then. The People's Exhibit number 1 is received. Give me just a moment. Here we are back on the record. I've had the opportunity to review the People's Exhibit number 1. The counsel believe that it forms a factual basis in which to pleading the court rules being complied with.
Yes, Your Honor.
Yes, Your Honor. As does the court, find the plea as knowing, voluntary, and accurate. As such, Ms. Jones, I find you guilty of assault and/or assault and battery. In particular, on March 31st, 2025, there was a video that shows Ms. Jones hitting, kicking, knee as the victim is lying in a fetal position by the what's commonly referred to as the old dam. The court will take judicial notice that is located here in the city of Cadillac, that is between Main Street and River or Wright Street on the what's now known as something along the lines of the Green Trail or the Green Pathway. The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned "Round 2." And this appeared to be all over some things that were said about another deceased mother. As such, I find that the elements are made out for an assault and battery, and that this would have been an unwanted, forceful, violent touching. Additionally, I believe the interests of justice are well established here in allowing the defendant to plead a no contest so as to not have her guilty plea used against her should the case of civil liability arise, although I question what the civil liability would be since there's no injuries, but I guess that's not really determined. Are we able to sentence today?
Yes, sir.
Mr. Hartel, any allocution?
Yes, thank you, Your Honor. No process, especially for civil liability, and copies to order the allegations for officer. What I will say is my client has my knowledge so long, stayed in constant contact with the defendant's office. Is very cooperative. She does have strong ties in community and also do well on probation. Highly motivated to do well and receive the benefit of the joy. I am in that situation to always advise my clients if they don't do well, there is the risk of jail and want to raise or adult life. She's a relatively young adult. She wants to be able to pursue marriage, career, ambitions at the moment. We're going to she's aware she goes to one year old file. She's going to do a wage assignment. She also has some friends with the courtroom for you throughout the procedures. I don't doubt will continue to support you on her as well. I ask the court to hold you. Survey, kind of 14-year-old, really shows judgment like maturity. However, the design does not have higher conditions that help file and this Jones is a life sentence still.
Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not?
Yeah, I don't show them on lady. That last familiar with this Jones of other things shows how where she was traveling. So
Well, I'm just trying to remember. I remember it seems like climbing on top of the school for the 4th of July. Was there charges on there?
That was resolved. So,
I'm going to be very honest with everybody. I don't plan on following this killer. She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground because of something that was said about somebody else's deceased mother, and then had the gall to post another video of it on TikTok. That's not somebody who's making mistakes. That's not what hiding or this type of thing is designed for. The delay of sentence is to allow the court to determine whether or not the person will be successful on a term of delay, a sentence, and hopefully follow through with the plan. From what I've seen from Ms. Jones and Mr. Carnes, if you tell me that charges weren't brought, I trust you on that. But I can tell you, and I'm not using any of my prior knowledge because clearly it's not full, but I do know from my time as the elected prosecutor too, and as judge, and I believe she has another case coming up that she has to be arraigned on with Judge Van Alt because I had a conflict on that because I was the elected prosecutor when that was arose. This is not a one-time mistake. Ms. Jones has been in and out of this, whether it's this court or the probate court, or somehow tied with other events. I'm not going to make a decision today. What I'm going to do is I'm going to set this over for sentencing. I'll allow both parties the opportunity to do some memorandums and try to convince me why I'm wrong in my thought process. But as I sit here today with the information I have, I cannot in good conscience let this just get, for all intent and purposes, swept under the rug.